Welcome to Session 6. We finish the three branches with the judicial branch, the courts. This branch has a quiet but enormous power. It decides what the Constitution actually means. By the end, you will understand the three-level court system, explain judicial review and the case that created it, and recognize the landmark Supreme Court decisions the GED loves to test. Article 3 of the Constitution creates the Supreme Court and lets Congress build the lower federal courts. What's unusual is how little it says. It leaves most of the structure to Congress. The defining feature is judicial independence. Federal judges are appointed, not elected, and they serve for life, removable only by impeachment. Why? So they can decide cases based on the law and the Constitution, never out of fear of losing an election. The federal courts come in three levels. At the bottom are the U.S. District Courts, 94 of them. This is where federal cases begin. Witnesses testify, evidence is shown, and a verdict is reached. If you lose, you can appeal upward to the Courts of Appeals, 13 circuits. They don't retry the facts. They review whether the lower court applied the law correctly. And, at the very top, sits the Supreme Court. One court, 9 justices. Its decisions are the final word and bind every court in the country. Let's look inside the Supreme Court. It has 9 justices, 1 Chief Justice, and 8 Associate Justices. Like other top officials, the President appoints them, and the Senate confirms them. A ruling needs a majority, 5 of the 9. When justices agree on the outcome but for different reasons, 1 writes a concurring opinion. When they disagree, they write a dissent. A dissent has no legal force today, but it can plant the seed for a future court to change its mind, which is exactly what happened on segregation. Now, the court's greatest power, judicial review. This is the power to examine a law and strike it down if it violates the Constitution. Here is the surprise. This power is not actually written in the Constitution. The court claimed it for itself in 1803, in the most important case in its history, Marbury versus Madison. Chief Justice John Marshall ruled that a law conflicting with the Constitution is simply void. By striking it down, he established that the Supreme Court is the final interpreter of what the Constitution means. The court is extremely selective. Each year, it gets 7,000 to 8,000 petitions, but accepts only about 60 to 80 cases. To ask the court to hear your case, you file a petition for a writ of certiorari, called cert. The court agrees to hear it under the rule of 4, if at least 4 of the 9 justices say yes. And if cert is denied, the lower court's ruling just stands. Importantly, that is not the Supreme Court agreeing or disagreeing. It simply chose not to take the case. Finally, a handful of landmark cases show up again and again. Marbury gave us judicial review. McCulloch versus Maryland confirmed federal supremacy and the implied powers of the Elastic Clause. Then, the segregation pair the GED loves, Plessy versus Ferguson in 1896, said separate but equal was fine, and Brown versus Board in 1954 overturned it, ending school segregation. Miranda versus Arizona gave us the Miranda warning, your right to remain silent. And Obergefell versus Hodges, in 2015, made same-sex marriage a constitutional right. Let's test it. In Marbury versus Madison, the court struck down part of a law as unconstitutional. Why is this the most important decision in its history? The answer is A. Marbury established judicial review, the court's power to strike down laws that violate the Constitution. Judicial review is what makes the Supreme Court the final voice on the Constitution. The court system itself was built by Congress, not by this case, so the other options don't fit. Let's recap Session 6. Article 3 gives federal judges lifetime terms to keep them independent. Cases climb from district courts to the Courts of Appeals to the Supreme Court, where 9 justices decide by a majority of 5. The court's defining power, judicial review, came from Marbury versus Madison in 1803. And remember the landmark cases, especially Plessy, then Brown, plus Miranda and Obergefell.